If you hold citizenship in two countries, or if you were born in one country and later became a citizen of another, what I am about to tell you in the next few minutes could directly affect whether you can travel to the United States, whether your pending immigration application gets processed, and even whether an already approved immigration benefit gets reopened and reviewed. This is not hypothetical. This is happening right now in 2026, and the details are complex enough that most people, including many dual citizens who believe they are fully protected, do not yet understand the full picture. So please stay with me through this entire video, because by the end, you will have a clear, practical understanding of what the new executive orders and policy changes actually mean for you. Let me set the stage. On December 16, 2025, President Trump signed Presidential Proclamation 10998, titled Restricting and Limiting the Entry of Foreign Nationals to Protect the Security of the United States. That proclamation took effect at 12:01 in the morning on January 1, 2026. And while much of the early news coverage focused on the expansion of the travel ban itself, which now covers 39 countries plus individuals traveling on Palestinian Authority-issued travel documents, what received far less attention was a separate but equally significant policy change that came from U.S. Citizenship and Immigration Services, which most people know as USCIS. Because while the travel ban proclamation is about who can enter the United States, the USCIS policy memorandum that went into effect alongside it is about something different, and in some ways even more far-reaching. It is about who can have their pending immigration applications processed, and whether already approved immigration benefits might be reopened for review. Let me break all of this down piece by piece, starting with the travel ban expansion itself, because understanding that foundation is essential before we get to the parts that most directly affect dual citizens. The June 2025 travel ban, which was Presidential Proclamation 10949, had already restricted or fully banned entry for nationals of 19 countries. The December 2025 expansion more than doubled that number to 39 countries plus Palestinian Authority document holders. Under the expanded proclamation, 19 of those countries are subject to what is called a full suspension. That means nationals of those countries are barred from receiving both immigrant visas, which are visas that lead to permanent residence, and non-immigrant visas, which are the temporary kinds like tourist, student, or work visas. 12 countries were already under full suspension from the June proclamation. The December expansion added 7 more to that complete ban: Burkina Faso, Mali, Niger, Sierra Leone, South Sudan, Syria, and Laos. An additional 20 countries are subject to what is called a partial suspension, meaning some categories of visas, particularly tourist, student, and exchange visitor visas, are restricted, while certain work visa categories may still be processed. Now here is the part that is critically important for dual citizens and for anyone watching this who was born in one of these countries but later obtained citizenship in a different, non-listed country. The travel ban proclamation itself does contain an explicit exception for dual nationals. According to the official text of the proclamation, a dual national of a listed country is exempt from the travel ban if that person is traveling on a passport issued by a country that is not on the restricted list. So for example, if you were born in Sudan but later became a citizen of Canada and you are traveling on your Canadian passport, the travel ban proclamation, by its written terms, does not apply to you. That has been confirmed by legal firms that reviewed the proclamation text, and it aligns with how similar bans were interpreted during the Trump administration's first term. However, and I want you to hear this very carefully, the USCIS policy memorandum that went into effect on January 1, 2026, operates on a fundamentally different basis, and it does not include that same exception. According to reporting from Gibney Law and analysis published by the immigration law firm Fragamen, which tracks federal immigration policy closely, the USCIS hold and review policy applies based on your country of birth or your country of citizenship, not on which passport you are using to travel. Let me say that again because it is the most consequential point in this entire video. Even if you are a dual citizen who is completely exempt from the travel ban when you cross the border, if you have a pending immigration benefit application on file with USCIS, a green card application, an employment authorization document, a change of status request, a naturalization application, and you were born in or hold citizenship from one of the affected countries, that application may be frozen right now under an indefinite adjudicative hold. The official USCIS policy memorandum, known as PM 602-0194, which was issued on January 1, 2026, directs USCIS officers to place a hold on all pending immigration benefit requests filed by or on behalf of individuals from high-risk countries, with that determination being made based on country of birth or country of citizenship. The memo builds on an earlier December 2, 2025 policy document and significantly expands its reach to now cover all 39 countries in the travel ban. As reported by Brown University's International Student and Scholar Services Office and by legal commentators at NAFSA, the National Association of Student Affairs Administrators in Higher Education, the practical impact is that applications will continue to be accepted and filed with USCIS, but final adjudications, meaning final decisions, may not be made until USCIS operationalizes new vetting procedures or otherwise lifts the hold. There is currently no stated end date for when that will happen. What immigration benefits are affected? The list is broad and includes some of the most commonly sought immigration benefits. Adjustment of status applications, meaning applications to get a green card from inside the United States, are on hold. Employment authorization document applications, which determine whether someone can legally work, are on hold. Applications to change or extend non-immigrant status are on hold. H-1B work visa petitions are on hold. Applications for advance parole, the travel document that allows people with pending green card cases to travel abroad, are on hold. And naturalization applications to become a United States citizen, are on hold for people from these countries. According to legal reporting covered by Immigration Monitor and Boundless Immigration, USCIS has also stated that it will re-examine immigration benefits that were previously approved on or after January 20, 2021, for individuals from these high-risk countries, meaning approvals that already happened can be reopened. There are some specific exceptions to the USCIS processing hold, and I want to be precise about these because they matter. Applications to replace a lost, stolen, or damaged green card using Form I-90 are still being processed. Applications for a new copy of naturalization or citizenship papers using Form N565 are still being processed. Applications for a certificate of citizenship using Form N600 are still being processed for most countries, though USCIS has noted that this exception does not apply to applicants from Yemen or Somalia due to specific document reliability concerns in those countries. Everything else in the broad immigration benefit categories is subject to the hold. Now, there is another layer to this that involves a particularly sharp concern about citizenship by investment programs. The December 2025 proclamation specifically named Antigua and Barbuda and Dominica as countries that were added to the restricted list, in part because of their citizenship by investment programs that allow foreign nationals to obtain a second passport through financial investment rather than residency. The administration's concern, stated in the proclamation, is that these programs present additional screening challenges because they allow individuals to obtain a second nationality without the kind of vetting that a traditional immigration process would require. And the USCIS policy memo makes clear that individuals who obtained citizenship by investment from a second country for the purpose of bypassing travel restrictions are specifically among those whose applications will receive heightened scrutiny. If you hold a CBI passport from a country like Antigua and Barbuda or Dominica, you should seek qualified legal guidance immediately about how this affects your specific situation. Let me also address a question that many viewers will be asking. What about people who are already inside the United States? The travel ban proclamation itself, by its terms, applies only to nationals of the affected countries who were outside the United States on January 1st, 2026, and who did not have a valid visa on that date. The official State Department advisory confirmed this. People physically present in the United States on that date, or those who held valid visas, are not subject to the travel ban entry restriction. Existing visas are not being revoked as a result of the proclamation. This is an important protection for those who were already here. However, and here is why it is so important to understand both policies together, being physically present in the United States does not exempt you from the USCIS processing hold. That hold applies based on where you were born and what countries you hold citizenship in, regardless of your physical location. So, if you are from one of the 39 affected countries, and you have been living and working legally in the United States for years, and you have a pending application with USCIS, your case is on hold. Your day-to-day status is not being removed overnight, but your pathway forward through the immigration process may be frozen until further guidance is issued. For those of you who are outside the United States right now and fall under these restrictions, the guidance from immigration attorneys across the country has been consistent and urgent. Do not plan international travel without first consulting a qualified immigration attorney about your specific situation. The risk of departing the United States and being unable to return, particularly if you need a new visa, is real and significant. Consular processing for nationals of fully restricted countries has essentially stopped. If you are outside the United States and do not have a valid visa, obtaining one under the current restrictions is extremely difficult, and in many categories not currently possible. If you do qualify for a national interest waiver, a rare exception the administration may grant on a case-by-case basis. Working with a qualified attorney to present the strongest possible case is essential. So what practical steps can you take right now? The first and most important step is to determine exactly where you stand. Pull out your documents. Know your country of birth. Know every country in which you hold citizenship. Compare that against the current list of 39 restricted countries, which is posted on the official State Department website at travel.state.gov and on the USCIS website at uscis.gov. Do not rely on a list someone shared on social media 2 months ago, because this list has expanded twice already, from 19 countries in June 2025 to 39 countries in January 2026, and the administration retains the power to expand it further. Reviews are mandated every 180 days, and the Secretary of State must report to the President on whether restrictions should be continued, modified, or supplemented. The situation is dynamic. The second step is to check the status of any pending USCIS applications. If you have a receipt notice for a pending case, log into your USCIS online account, or check your case status on the USCIS website. If your case has been pending longer than expected, and you are from one of the affected countries, it may be subject to the processing hold. USCIS has acknowledged there is no current end date for the freeze. Cases are still being accepted. You can still file applications, but final decisions may not come until the agency completes its new vetting procedures. For employment authorization in particular, this creates very real and immediate challenges because work authorization expires, and a delayed decision can mean a gap in your ability to work legally. Third, if you have international travel planned, consult an immigration attorney before you leave. This is not a precaution for extreme cases only. This is basic due diligence in the current environment. The consequences of leaving the United States while the travel ban and USCIS hold are both in effect, particularly if your visa expires while you are abroad, or if you are from a country on the full suspension list, can be severe and in some cases irreversible. The immigration law community has been consistent. This is a moment to move very carefully. Fourth, if you have family members abroad who are from affected countries and who are in the process of obtaining visas to come to the United States, they need to understand that the visa issuance process has been suspended or significantly restricted. A key detail here: unlike the June 2025 proclamation, the December 2025 expansion eliminated categorical exceptions that previously existed for immediate family members of U.S. citizens. things like spousal visas and certain immigrant visas for parents and children. Those categories were previously given a broader pass. Under the new proclamation, they are now subject to the same restrictions as everyone else, and waivers are only available on a case-by-case basis through the Secretary of State or Attorney General when travel is determined to serve a national interest. Fifth, for everyone watching this, dual citizen or not, from an affected country or not, this is a moment to make sure your immigration documents are organized and accessible. Know the expiration dates on your visa, your work authorization, your advance parole document, and your green card if you have one. Set reminders. Do not let documents expire without a plan in place, because the window for getting renewals processed quickly has narrowed significantly under the current environment. And finally, the critical overarching message. If your situation is complex, do not try to navigate this alone. The intersection of the travel ban proclamation and the USCIS processing hold creates a dual barrier environment that immigration attorneys have described as one of the most significant restrictions on legal immigration in modern history. The policies operate on different bases, apply to different populations, and have different exceptions. Getting authoritative professional guidance for your specific situation is not a luxury. In 2026, it is a necessity. I want to take a moment before we close to speak directly to those of you who are sitting with anxiety right now. People who followed every rule, waited patiently for your cases to be processed, and are now watching the rules shift around you. Your feelings are valid. What is happening is genuinely unprecedented in scope. At the same time, the courts remain active. Federal judges have reviewed travel ban policies before. Immigration advocacy organizations, law school clinics, and pro bono legal networks are working on these issues every day. You are not without resources, and you are not alone. As of February 16, 2026, the date of this recording, the travel ban covers 39 countries and Palestinian Authority document holders. The USCIS processing hold applies based on country of birth and country of citizenship, and it includes dual citizens who are otherwise exempt from the travel ban for entry purposes. The hold covers most immigration benefit categories, including green cards, work authorization, status changes, and naturalization. Reviews by the Secretary of State are required every 180 days and could result in changes to the list in either direction. No end date has been announced for the USCIS processing freeze. If this video helped you understand what is happening and what you need to do, please like it right now and share it with someone you know who might be affected. A family member, a colleague, a friend who has been waiting for their immigration case to move forward. Your share could make a significant difference in someone's life. Subscribe to Immigration News today and hit the notification bell so you are informed every time we publish new guidance. We cover changes to federal immigration policy, USCIS updates, travel rules, and official DHS and State Department guidance every single day. You deserve accurate, clear information, and that is exactly what we are here to provide. The description below this video includes official resource links to uscis.gov, travel.state.gov, and the full list of affected countries, along with a quick reference checklist of the steps we covered today. Please use those resources. A final note, everything shared in this video is for informational purposes only and does not constitute legal advice. Immigration and travel policy can change, and as we have seen, it has been changing rapidly. Please verify all information relevant to your specific situation with official government sources at uscis.gov and travel.state.gov, or consult a licensed immigration attorney or accredited representative for personal guidance. The content of this video reflects verified information available as of February 16, 2026. Thank you for watching, and thank you for trusting Immigration News Today to keep you informed. We will see you in the next video.